It's Kelly's favorite lawyer.
Thank you very much.
You're welcome.
Steve Moskowitz is here, and I'll give you your choice.
Okay.
We can discuss statutory rape or the Americans with Disabilities Act.
Well, I discuss both of them.
Well, we're going to do both. I'm giving you your choice.
Statutory rape.
Okay, good. No, as you're fully aware, Pete Rose has filed a defamation suit against John Dowd, who was working for baseball at the time, that he investigated Rose on gambling charges. And among the things that Dowd claimed that he discovered was that Rose, as a player, was having an associate run young girls for him, like bring young girls to him. And one of them basically had said, as a result of Rose's defamation suit, I guess in discovery, that Rose had started sleeping with her when she was 14 or 15. Now, this is not about whether Rose is going to go to jail for that, because I understand the statute of limitations.
Oh, well, hold on. The statute of limitations at the state level is 20 years. He's safe from that, but he took her across state lines. Under the Mann Act, if you take an adult across state lines, it's 10 years. But if you take a minor, it's for the rest of the life of the minor. So he's not out of the woods.
Okay. I stand corrected then.
That's why you have me.
Okay. I was more interested, though, until you enlightened me on that, about the John Dowd situation. He told this story on a radio show in 2015, which is why Rose has filed the defamation suit against him. And while I understand that the statute of limitations doesn't count, what is the difficulty of Rose being able to prove that he was defamed? Does he have to prove that it was, as it is in libel cases, that it was not only injurious to his character and business, but that it was untrue? If someone told him, and he found out subsequently through his own investigation, that this happened, is that sufficient?
There's a couple problems here. One, Pete Rose is a public figure, so that means you have to do something much worse to him than a regular person. And the other thing is truth is a defense. So you say, well, wait a minute, you know, some young lady testified in a depot. That's some real problems. And, you know, Pete should have really thought twice and 3 times and 5 times before he filed this suit, because if he hadn't, it might have just gone away unnoticed by hardly anybody. Now I got a lot of people looking at it. But
in terms of this case, isn't it kind of a he said, she said kind of a thing? He said, yeah, we had a relationship, but she was 16, and in the state of Ohio, 16 is illegal consent.
Yes. She's
saying they did go across state lines, but he disagrees with that. So it's a
sure.
So where's the proof in all this?
Well, again, the problem is it's brought out in public, and just as he's trying to come back, like just as he's trying to come back, he had to cancel being in Philly, because let's not forget the court of public opinion. So again, if he consulted with me, I'd say, look, Pete, you really don't want to do this. He's causing himself problems. He's trying to get back. Now you have something like this going to push him further out again.
One more quick question on this, then we'll move to the ADA case. Does the question of the defamation suit depend on how Dowd answered the question on the radio? If he said, I know for a fact X, as opposed to I was told X. If he said, I was told X, does that indemnify him? No, because what happens is you're supposed to go ahead and check things out. If somebody said to you, oh, you know, on my way in, somebody told me that Ray's an axe murderer. And I say, you know what, that... Well, you kill 7 people with an axe, you just get a reputation.
Yeah, you know, things happen.
Yeah.
So that's the problem. You have a duty to find things out, not just damage somebody.
Okay. On the ADA suit, very briefly, a woman who goes to 49er games is pursuing an Americans with Disabilities Act claim against the 49ers, not on her own behalf, but on behalf of her husband, who I guess needs a wheelchair. Apparently, the judge has ruled that she can pursue this, I guess technically as a third party. Well, actually, straighten me out.
Under the ADA, not only can a disabled person file suit, but the person that's with them can file suit as well. But here, my bet is she's going to lose. And the reason is, first of all, I am sure any new building that comes up, you have all these ADA experts go through with a fine-tooth comb and make sure it's compliant. That's one thing. And the next thing is the entire place doesn't have to be suitable for wheelchairs. What they need to do is make a portion of it suitable so that a person can go and enjoy themselves. And on the website to buy the tickets, they even say, look, this section, you know, if you're in a wheelchair. So the bottom line is, it appears that the stadium has complied with the ADA and she's going to get thrown out, which is different than the initial motions are, you have no case, nothing, throw them out on the law. Whereas when it goes further on, they're going to find out that the facts are such. That's why I think she's going to lose and the stadium's going to win.
Now, the judge said, though, that the wife adequately alleged frustration, physical exhaustion, other difficulties related to helping her husband navigate around Levi Stadium with his wheelchair. So to this judge, she has shown enough of reason to bring this case, obviously, under ADA claims. So the fact that it is a new stadium, though, this shouldn't even happen, right? Because they are under such strict when they're building. So does that almost strengthen a case, though, if you're already bringing up a claim against Levi Stadium?
No, because what happens when you try to throw out a case at that early stage, what happens is you have to show that there's no chance. What's going to happen later on is the parties go ahead and present their case and they say, look, we've had these experts, they have these big companies that do that, who certified everything is fine, is compliant. That's why I really think she's going to get thrown out. But that's a big, big difference in a case. At the beginning, to throw it out is tough because it's just saying that you have no facts. She'll go in, she'll testify what happened to her. Then the company say, well, wait a minute, you know, she went to the wrong section. They did the accommodations that were necessary.
It's interesting because I would think a new stadium like Levi's Stadium wouldn't have any issues.
No, even the buildings like here in San Francisco, you have all these experts going through making sure, because there's very strict rules. Somebody comes in with a little measuring tape and say, wait a minute, this curb is too high, and boom, you get sued. And when you get sued, not only is the owner of the building liable, they can sue the tenant. I've done those cases, defended clients where they say, oh, the landlord did. Usually that's older buildings, and normally once even an older building, you have somebody go through and fix things. So again, my guess is the stadium is going to comply and the stadium is going to win.
See, I would sue on the basis that this guy in a wheelchair was forced to watch 49ers.
Yes.
And I
now that's a case.
That's a different story.
That is indeed.
Story.
We will see you next week.
Always a
Thank
pleasure.
you,
Thanks,
Steve.
guys.
Okay.
All right, coming up next on the Happy Hour, we're talking a little A-Rod, owning his stuff. I can't say the word he actually said, but it's
Yes,
working
you
in his
can.
favor.
It's cable
Say
television.
it. Say it. Say it. You.